number 22-186.
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand.
Get ready for another bizarre courtroom twist, this time featuring Marcus Campbell, a self-proclaimed sovereign citizen who refuses to play by the usual rules. From the moment he speaks, Marcus denies being himself and claims he's just the authorized representative of his own name, as if he's acting out a script from a legal drama. When the judge tries to get clarity, Marcus fires off a confusing string of legal-sounding phrases that seem more inspired by online theories than anything recognized in court.
The status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful
every legal step. They sent a demand letter, filed the case correctly, served Marcus properly, and got a reply packed with confusing and unrelated arguments. Ironically, Marcus's own documents admit he owes the debt, making it an easy decision for the judge. With no real defense on the table, she swiftly rules in JP Morgan's favor. It's Marcus's first official courtroom defeat, and a clear sign that internet-inspired legal theories aren't holding up under real scrutiny.
Calendar, Mr. McCardle's.
On solid legal arguments. Next voice.
Were filed, the last of which is a response to plaintiff's counter-defendant's motion to strike, in which the defendant has a number of things, but the chief among them in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our client, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because the defendant is
Portfolio recovery comes fully prepared, complete with detailed records, invoices, and payment history all in order. Marcus, meanwhile, denies everything, even though he's been making payments for years without objection. The judge reviews his latest filing, which is filled with tangled legal language and weak reasoning. But once again,